Utah law does not bar children from testifying, even when a PGAL is appointed. Here's the truth most people never hear in Utah custody litigation. Utah does not prohibit children from testifying. Period. Not even when a private guardian ad litem, or PGAL, is involved. There is no statute, no rule, no case that creates a blanket ban. That restriction simply does not exist. Yet you'll hear judges, commissioners, and PGALs and other lawyers talk as if children are automatically silenced the moment a PGAL appears, as if the PGAL becomes the child's voice and the actual child is pushed aside. That's not the law, that's culture. It's a culture that too often works against accuracy and fairness. A PGAL is an attorney, not a ventriloquist. A PGAL can advocate, but a PGAL cannot replace a child's testimony, cannot serve as a witness, cannot paraphrase the child's thoughts as if that's evidence. If a child says, "I want to testify," the legally correct response is simple. Let the child testify in a proper, recorded, in-camera interview. Some courts avoid child testimony because they don't like it. They find it uncomfortable or emotionally messy. They'll say things like, "It's too stressful," or "Kids aren't reliable," or "That's what the PGAL is for." Those are preferences, not legal standards. No judge can bar a competent witness, adult or child, just because the testimony might be unpleasant or inconvenient. And let's be honest, sometimes "I'm protecting the child" really means I don't want to deal with that child and what that child might say. That's not protecting the child, that's protecting the adults. A child with relevant information about safety, home life, what actually happens during parent time, and other issues is often the only first-hand witness. The idea that we shouldn't hear from the one person who actually lives the experience is absurd. Judges know that speculation about trauma is not evidence. They know that children testify in juvenile court, criminal court, civil court, and protective order cases all the time. If a respectful, private conversation with a judge were truly traumatizing, the entire legal system would collapse. Children are not as fragile as some adults pretend. The bottom line? The law permits the child to testify. The law favors first-hand evidence. And nothing, absolutely nothing, gives a PGAL the authority to silence a child who wants to speak or is willing to speak. If we want better custody decisions, we have to stop treating children as decorations in their own cases. When a child is competent, willing, and has relevant information, the court has a duty to hear that child. Not hearsay, not summaries, not interpretations, but the child's own voice.